And the building was in, I felt that it was not fair to stay in a place. I felt like I needed to immediately leave, but there was no light above my door to light the stairway, the 14 cement stairs to my front door.
You filed a claim against Lakeville Village Apartments. And I'm going to swear you both in, but if I understand correctly, you're asking for your deposit back. The position of the Lakeville Village Apartments is this deposit just went to cover a last month's rent. And if I'm wrong about any of that, then I'm going to invite both of you to correct me. So Ms. Lane, could you unmute yourself, please? I still can't hear you. There you go. Try it now.
Your Honor, that was not my last month's rent. That was
okay, ma'am. I'm going to stop you, please. Could you raise your right hand, please?
Yes, sir.
Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, so you can put your hand down. So go ahead and take it from the top then, and just tell me why you believe the Lakeview Village Apartments owes you $900.
Your Honor, I gave my written notice on her desk when she submitted that reasonable accommodation request. I printed on a card that I would be moving August 31st, 2022, and she tried to provide a late reasonable accommodation request. The request, Your Honor, was for a refrigerator that fit the kitchen. The refrigerator in the kitchen, the door would not open wide enough to access the produce drawer. I completed the terms of my lease. I asked for a refrigerator which fit the size of the kitchen, and I did not receive that. The reasonable accommodation request was denied, and honestly, I just wanted them to place a refrigerator in there that was properly fitted for the kitchen. I gave my notice. I completed the terms of my lease contract. And I deserve my deposit back. I left my apartment in beautiful condition. I don't understand why she charged me rent for September at all. It makes no logical sense to me. She refused to go through the checkout process.
Okay, so ma'am, what day did you give your notice?
I gave my notice when I paid rent in the
a date, ma'am.
The date?
What date?
The date was July 31st.
And when did you move out?
I moved out August 31st. I walked through September 1st to show her the empty, clean apartment.
Okay, so let me, Ms. What's your name, ma'am, from the Lakeview Village Apartments?
Liana.
Okay, could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
I'll hear from you.
The card that I have received from Ms. Lane is here. I received through the night rent drop box on September 4th. That was not legal proper notice. The encounter that I had with Ms. Lane after denying her reasonable accommodation was 3 days prior to the end of the month, where she had stopped me in the parking lot and told me she would be moving. I notified her that that is not legal notice, and that if she is going to be turning in her keys at that time, that she would still be obligated for the following month's rent, as is also stated in her signed lease agreement.
I heard it. So you're saying then that she owes for September?
Correct.
And then, so you gave...
Your Honor.
So ma'am, coming back to you there, Ms. Lane.
Yes.
She's saying she didn't get notice on, you said you gave notice on July 31st.
Your Honor, I received
She says she didn't get notice till
message.
September. So ma'am, please wait till I'm done to ask my question before you answer it.
Your Honor.
Yes, go ahead.
I received a message from Lakeview Village. Says, hello, Patricia. I'm sorry to hear our inability to overrule Washington state laws regarding reasonable accommodation is a deciding factor for you to leave us. Please let me know if there's anything further I can do. I felt I had received confirmation that
Once sworn in, the tenant explains why she believes Lakeview Village Apartments owes her deposit back. She claims she left written notice on the manager's desk stating she would move out by August 31st, 2022.
that she knew that I was leaving. This confirmation was given the beginning of August from
Okay,
Lakeview
so I
Village.
hear someone in the background, ma'am. I'm not sure who that is. But if someone's, I need to hear testimony either from you, or if you want to call witnesses, you can have that person testify, but I need to be able to hear from you, okay?
Yes, Your Honor.
Because when someone's talking at you like that, that affects my ability to listen to you, to what you're saying. If you
My
have witnesses
apologies.
you wish to have testify, that's fine. We can call them. I'll hear from them.
No, my apologies,
Okay.
sir. I felt that I had received confirmation.
No, but what about the notice? I saw that, but the notice, I
That
mean, a
notice
copy
was
of
not
the,
the notice. I apologize. I'm listening.
I need to see you said you gave notice on July 31st. She's saying we didn't get that. We didn't get any sort of notice until she ran into a parking lot or on, some card that was sent on September 4th, I believe. Is that correct there?
Yes,
No,
Your
that
Honor.
is,
So did you give a written notice on July 31st?
I did.
You have a copy of it?
I do not, Your Honor. She did not allow me, she did not provide me with a new lease when I requested a new lease. She did not allow me the checkout process when I let her know that I was leaving to give my notice. When I let her know that, I was ready to complete those forms, she refused to provide them for me, stating that it was not good enough that I give my daughter's forwarding address as part of her move out process. I was
So
determined to
say that
leave.
again. Say that again, ma'am.
I went to her office. I asked to go through the checkout process, and she refused to provide me all that or a new lease. Honestly, she refused to check me out because I did not have a new lease in place to give her a forwarding address. I offered to give her my daughter's address as a forwarding address, and she stated that that was not good enough for her. So when I asked for a new lease, she did not provide it. When I asked for it to go through the checkout process, she did not allow that because she said that she needed my new address. And I said, all that I had to give her at that time was my daughter's as a forwarding address.
What day did this take? I don't understand that. I mean, I don't, and again, what I'm asking is I need to see some sort of, a lot of times people keep copies of it. They should. If you're going to give a notice that you're moving out, that's what I want to see.
Well, I don't have that. I do have confirmation that she, in early August, that she knew that she was sorry to hear that I was leaving. I accepted that as confirmation that she knew that I was no longer going to be living at Lakeview Village. The message
Okay,
from
so-
Lakeview Village states clearly, I'm sorry, our inability to overrule working state laws regarding reasonable accommodation is a deciding factor to leave us. When I provided my notice, it was on a simple business card at her desk when I requested the reasonable accommodation of a smaller refrigerator that would open well enough to be able to access the produce store. The building at the time when I moved out, I felt I fled. I had no light above my doorway. The building is under construction and I just had to go.
How long did you live there, ma'am?
I lived there for the full term of my lease, 1 full year plus several weeks. I completed the term of my lease. I gave my notice. She refused to check me out. She refused to provide me a new lease. I was in a very difficult situation. I was not receiving the refrigerator I needed that would.
The refrigerator dispute takes center stage next. The manager explains the unit was a standard apartment sized refrigerator and that tenants often adjust its position to make it functional in the compact kitchen layout.
Actually opened the door would open wide enough for me to be able to access the produce store, was what I was requesting from Lakeview Village, which honestly didn't seem too much under construction, which was a dangerous situation. No light at my door. I completed the terms of my lease.
It expired.
My lease expired.
You, ma'am, from the, I have what I was looking for. It said, "Hello, Patricia. I'm sorry to hear our inability to overrule Washington state laws regarding reasonable accommodations is a deciding factor in your decision to leave us." When did you send that?
I'd have to go back and check the email. She had stated in a prior email that she would be seeking another apartment if we did not approve this reasonable accommodation. So at that point, that was I understand you will be looking for something else, but that does not constitute a notice that she intended to vacate.
Got it. But when was that sent?
I believe that was in August.
What about the refrigerator? What's the story on that?
So it's a standard 15 cubic foot apartment sized refrigerator in the home. I affectionately refer to as my one bedroom apartment kitchens as a one butt kitchen. They are very small. At the time of her move in, I had even suggested that many people tend to turn them sideways so that the door opens out into more so the dining space than into the kitchen. It just tends to work better for a lot of people. And unfortunately, she didn't like that answer.
Okay. So, ma'am, Ms. Lane.
Yes.
So you're the plaintiff in this case.
Yes, I am.
As a plaintiff, you have certain, I guess, responsibilities, the way I'd put it, is a burden of proof. In criminal cases, you probably heard the term proof beyond a reasonable doubt. In civil cases, which this is, it's by a preponderance of the evidence. Is it more likely than not? And, if you fail to meet that burden, then it's a verdict in favor of the defendant. And that's kind of where I'm coming down on this case as well. That's why if you're going to give a notice of something of that sort, it's a good idea to keep a copy of it. And that's why when people serve stuff, when we get proof of service, they need to have proof of service filed in the court. And, if you need to show that you gave notice, you need to keep a copy of the notice that you have given. So I will find that I'm not convinced by a preponderance of the evidence that appropriate notice was given. And so I'll find for the defense. And so this case will be dismissed.
Your Honor.
Yes.
When I requested the checkout notice to go through the checkout process with Ms. Sheely in her office at Lakeview Village, she refused to do so. Your Honor, when I requested a new lease with Lakeview Village, she did not provide me one. All I could do was print on a piece of paper and set on her desk that I was leaving. The confirmation, it was clear. I completed the terms of my lease. I left the apartment in beautiful condition.
Despite the ruling, the tenant continues to speak, repeating that she fled a dangerous situation and did her best under difficult circumstances. She insists she completed her lease, left the unit spotless, and was treated unfairly.
I fled from a dangerous situation. There was no light above my stairway to enter and exit the building. I had to leave. I had no choice. I did my best to give her notice. I spoke with her in June. I spoke with her in July. In July, I left a note on her desk stating clearly that I would leave. In August, same thing. She denied a reasonable accommodation, which was her way of dealing with the fact that the refrigerator in the kitchen was not fully accessible. She left that to my condition. She requested that a doctor fill out information and send to her for a reasonable accommodation. Honestly, I was not treated very well by Lakeview Village, and I feel I deserve my deposit back. I completed the terms of my lease. I spoke with the manager in office and gave written notice on her desk on a piece of paper because she would not go through the checkout process with me. I am beside myself. You know, I'm trying to prove to you
Right.
that she
And
knew I was leaving, that I did my best to do the checkout process with her. She was not cooperative, and the building was in, I felt that it was not fair to stay in a place. I felt like I need to immediately leave, but there's no light above my door to light the stairway, the 14 cement stairs to my front door. I fled.
Okay, so ma'am, again, that's my decision. I'm going to stick with my decision, and that'll conclude the case here today. If you wish to appeal this, you can, but that's what I'm going to do here today.
I don't feel this is fair. I'd like to.
I understand. I do understand that, but that's the decision I'm making here today. And you and the representative from the Lakewood Village, you're free to leave the Zoom call there.
Thank you,
Yeah, well-
Your Honor. Have a nice day.
The refrigerator was there from day one, and the landlord wasn't obligated to replace it. The judge saw through the contradictions and focused on what mattered. This case is a reminder that courts don't rule on feelings, they rule on proof. If you don't document your notice, you don't have a case. So what do you think? Was this a tenant pushed too far, or a lesson in why paperwork matters more than excuses?